Hey everyone, and welcome to This Explainer. Today we're stepping totally outside the realm of everyday local lawsuits, and we're diving headfirst into the high-stakes, incredibly messy, and honestly fascinating world of international shipping disputes. We're going to look at exactly how nations wield this immense legal power over massive vessels that are traversing the globe. So let's just jump right into it.
I want you to picture this scenario for a second. Let's say a massive cargo ship, owned by some shadowy foreign corporation based halfway across the world, completely destroys your precious cargo and then simply sails away. They flee your country's waters. The owner refuses to answer your calls, they don't have any local offices, and tracking them down seems utterly impossible. So what do? How do you actually sue a billionaire across the globe? Do you just take the loss? Well, maritime law actually has a very specific, almost unbelievable answer to this exact problem. And that answer lies in admiralty law. Now, technically, that's defined as a branch of jurisprudence regulating maritime matters. But the absolutely crucial point here is its superpower. It has the ability to enforce claims by literally arresting a ship. And to be clear, we aren't talking about arresting the captain. We are talking about the judicial sovereignty of a state to detain a multi-million-dollar steel behemoth while it's sitting within its territorial limits. It's just a stunning display of legal authority. Now, there's a core distinction here that makes admiralty law so unique compared to regular common law. In normal lawsuits, you proceed in persona, which basically means proceeding against a person, like the ship owner. That's how we think of normal lawsuits, right? You sue the person who wronged you. But admiralty law introduces something called in rem, which means proceeding against the property, the ship itself or its cargo. It's this wild, almost personified legal workaround where you bypass the missing owner entirely, and you essentially sue the actual ship as if it were a living, breathing entity. Section 1. Origins of Admiralty Law. So how did courts actually develop this authority to hold ships hostage? Well, it essentially developed in England, an island nation deeply reliant on sea commerce. Originally, Lord High Admirals handled these disputes based purely on custom, but it got complicated. Back in 1389, a UK act literally had to limit admiralty power to just things happening exclusively on the sea, mostly because they were constantly fighting with regular common law courts over jurisdiction. But fast forward to 1840 and 1861, and the British Parliament changes course. They actually expanded admiralty court powers to deal with cases inside the country, including damage done by ships. Then, in 1890, the Colonial Courts of Admiralty Act passed this massive power down to British colonies, including India. And here's the brilliant part. When India became independent in 1950, Article 372 of the Indian Constitution essentially froze these existing laws, allowing Indian high courts to just continue exercising this immense admiralty power. But there was a massive, glaring flaw in his frozen colonial-era framework. Because Indian law was essentially tethered to that old British Act of 1861, its power was restricted. The 1861 limitation meant that an admiralty court had jurisdiction over disputes involving inward cargo, so goods coming into the country, but it had absolutely no jurisdiction over outward cargo. If a dispute popped up over goods leaving the country, the courts were legally powerless to arrest the foreign ship. I mean, this was a massive loophole just waiting to be exploited. Section 2. The MV Elizabeth's Landmark. And, of course, this loophole was finally exploited, which brings us to the whole mystery of the MV Elizabeth. This seriously plays out like a maritime detective story. So we have a plaintiff based in Goa who hasn't been paid for their goods. The foreign-owned ship, the MV Elizabeth, is showing some real shady behavior right from the jump. It leaves the Marmagoa port without even issuing a bill of lading, which is basically the official receipt for the cargo. Worse than that, it deliberately delivers the outward-bound cargo to the consignees, even though the plaintiff specifically directed them not to, because, the price hadn't been paid. It's a blatant breach of duty, but the ship just sails away. However, luck is kinda on the plaintiff's side here because the MV Elizabeth eventually docks back in India over at the port of Visakhapatnam in Andhra Pradesh. So the plaintiff immediately files a suit in rem against the ship itself to have it arrested. But right here is where the tension really spikes. The defendant, the foreign owners of the MV Elizabeth, they raise a massive objection. They point straight back to those old rules. They argue, hey, this dispute is about cargo carried from an Indian port to a foreign port. That's outward cargo. Based on the 1861 limitation, your court has absolutely no jurisdiction to arrest our ship. You have to let us go. So the entire concept of modern Indian admiralty power was suddenly on the line. Does the court actually have the power to stop this ship? Well, the case makes it all the way to the Supreme Court of India, and here is the climax of our story.
the Supreme Court delivers a landmark ruling. They declare that after the promulgation of the Constitution, Indian high courts possess admiralty jurisdiction entirely uninhibited by the archaic limitations of that 1861 English Act. They basically severed those colonial chains. The court confirmed they indeed had the ultimate power to arrest the vessel, outward cargo, inward cargo. It didn't matter anymore. Justice was served.
Section 3, Scope of Admiralty Jurisdiction. So what exactly triggers this incredible power today? What gets a ship arrested right now? Well, the legal sources outline 14 specific points of jurisdiction, which we can essentially break down into 3 clear themes. First up, vessel damage. So if a ship hits your dock, or maybe there's a dispute over a ship's mortgage. Second, labor and services. And this one is huge. If a ship owner tries to skip out on paying the master or the crew their hard-earned wages, or if they refuse to pay for a towage, that ship can absolutely be arrested. And third, contracts and cargo. So if goods are lost or damaged, or if carriage agreements are broken, essentially almost any major, legitimate dispute relating to the operation, the cargo, or the crew of that vessel gives the court the right to freeze the ship. Section 4, How to Arrest a Ship. So what are the exact mechanics here? How do you physically arrest a gigantic merchant vessel? It's a really high-stakes, fast-moving, step-by-step process. Step 1, the claimant files an application for arrest in an admiralty court. Step 2 is where the magic really happens. The court issues a formal warrant of arrest. And this warrant comes with direct orders to all port authorities, customs, and harbor masters, completely preventing the vessel from sailing. The ship is officially trapped. Now, on to step 3. The ship's owners are losing thousands of dollars every single day that ship sits idle. But to free it, they don't necessarily have to settle the whole lawsuit right then and there. Instead, they just have to deposit adequate security, like establishing a massive fund or providing a bank guarantee that fully covers the claim. Finally, step 4. Only once that money is safely locked away in the court's control is the vessel cleared to sail. Your claim is officially secured, no matter what happens to the owner later on. But what if the owner goes bankrupt? Or what if they just decide to abandon the ship entirely because the debt is actually higher than the ship's value? Well, when owners fail to put up that security, the drama definitely escalates. The court literally has the power to sell the vessel at auction to realize the funds. And when that money comes in, everyone starts fighting for a piece. The priority of who gets paid first is subject to international conventions. And this part is kind of fascinating. Salvage claims actually rank first. Why? Well, because those heroic salvagers who saved the sinking ship in the first place are the ones who made the property available. If they hadn't saved it, there'd be nothing to sell at all. So they get paid before anyone else.
Okay, as we start to wrap up, I want you to consider one final, really mind-bending legal scenario. We just learned that you can sue the specific ship that wronged you. But what if that guilty ship, let's say the MV Elizabeth, just simply never returns to your country's waters ever again? Has the owner totally escaped justice?
Well, not in admiralty law. And this brings us to an absolute mic drop concept known as sister ship arrest. Let's say ship A destroys your cargo and never returns. But a year later, ship B, an entirely different vessel that is beneficially owned by the exact same company, docks in your port. Admiralty law says, tag, you're it. You can literally arrest ship B to pay for the crimes of ship A. It's just this inescapable, ingenious reach of modern maritime law that ensures negligent billionaires can't simply hide their assets across the oceans. But it does leave you wondering, as massive mega corporations continue to obscure their ownership behind increasingly complex webs of shell companies, is this powerful legal tool going to be enough to keep catching them? Something to think about. Thank you so much for joining me for this explainer. Until next time, stay focused and keep learning.